What's up, everyone? Welcome back to BYG Law University. Today, I am your host, Mr. Big, and whether you're studying for the bar, preparing for your criminal law final, or just trying to understand how the legal system actually works, you're in the right place. Today, we are breaking down criminal law from the ground up. We're talking essential elements of a crime, mental states, homicide, property offenses, inchoate offenses, defenses, all of it. So let's get right into it. So the first section is regarding essential elements of a crime. So here's what most people get wrong. You cannot just commit a bad act and automatically be guilty of a crime. The law requires proof of 4 core elements. Miss one of those and the prosecution's case falls apart. Almost all crimes require proof of 4 core elements, and what you need to know is every single one of them. The first is the physical act, which lawyers called actus reus. The defendant must have either performed a voluntary physical act or failed to act under circumstances where the law imposed a legal duty to act. And here's the critical piece on failure to act. A failure to act only creates criminal liability if 3 conditions are all satisfied. There must be a legal duty to act, whether that duty arises by statute, contract, or relationship. The defendant must have had knowledge of the facts giving rise to that duty, and it must have been reasonably possible for the defendant to actually perform it. All 3 must be present. The second element is the mental state, which lawyers called mens rea. The defendant must have committed the offense with a culpable state of mind. Now, here's something people constantly get wrong. A defendant does not need to know that their conduct is illegal to be guilty of a crime. Ignorance of the law is no excuse. That rule does not move. The third element is causation. There must be a causal connection between the defendant's act or failure to act and the harmful result that occurred. The fourth and final element is concurrence. The required mental state must exist at the same time the physical act occurs. You cannot form the intent after the fact and try to attach liability retroactively. The mental state and the physical act have to line up simultaneously. Section 2, the mental state requirements. So, not all crimes are created equal, and the mental state required can be the difference between walking free and spending decades behind bars. Under the common law, there are 4 different mental states, and the one that applies depends on the specific crime charge. The first is specific intent. Specific intent requires that the crime be committed with a particular intent or objective in mind. You cannot conclusively prove specific intent just from the act itself, but the manner in which the crime was committed can certainly be evidence of that intent. The specific intent crimes are solicitation, which requires the intent to have the person solicited commit the crime. Attempt, which requires the intent to have completed the crime. Conspiracy, which requires the intent to have the crime completed. First degree murder, which requires premeditated intent to kill. Assault, which requires the intent to commit a battery. Larceny and robbery, which require the intent to permanently deprive another of their interest in the property taken. Burglary, which requires the intent to commit a felony inside the dwelling. And forgery, false pretenses, and embezzlement, all of which require the intent to defraud. The second mental state is malice. Malice crimes require a reckless disregard of an obvious or high risk that a particular harmful result will occur. Here's an important distinction that you need to lock in. Defenses that apply to specific intent crimes like voluntary intoxication do not apply to malice crimes. The only two malice crimes are common law murder and arson. The third mental state is general intent, and this is the catch-all category. General intent only requires that the defendant intended to commit an act that is prohibited by law. Whether they intended the actual result is completely irrelevant. General intent crimes include battery, rape, manslaughter, kidnapping, and false imprisonment. The fourth is strict liability, and strict liability is the highest standard. It only requires that the defendant voluntarily committed the act regardless of any intent whatsoever, and defenses that negate state of mind, like mistake of fact, are simply not available. Strict liability offenses include statutory rape, selling liquor to minors, and bigamy in some jurisdictions. Now, the Model Penal Code mental states. The Model Penal Code threw out the old common law framework and replaced it with 4 cleaner categories. Know these because they show up everywhere. The Model Penal Code eliminates the common law distinction between general and specific intent entirely, and it replaces it with 4 categories of its own. The first is purposefully. A defendant acts purposefully when their conscious objective is to engage in the conduct or to cause a certain result. The second is knowingly or willfully. A defendant acts knowingly when they are aware that their conduct is of the nature required by the crime, or that the circumstances required by the crime exist. The third is recklessly. A defendant acts recklessly when they consciously disregard a substantial and unjustifiable risk that the material element of a crime exists or will result from their conduct. That risk must constitute a gross deviation from the standard of conduct of a law-abiding person. The fourth is negligently. A defendant acts negligently when they fail to perceive a substantial and unjustifiable risk that a material element of a crime exists or will result from their conduct. And here's the crucial distinction between recklessness and negligence. Recklessness is a conscious disregard of the risk, while negligence is a failure to perceive the risk at all. Both must constitute a gross deviation from the standard of a reasonable person in the same situation. Now, Section 3 is common law criminal homicide. So, murder, manslaughter, felony murder, these aren't just terms from a television show, and the line between them can mean the difference between life in prison and walking out with a lesser charge. So, common law murder. Murder is the unlawful killing of a human being with malice aforethought. And malice aforethought exists when there are no facts reducing the killing to voluntary manslaughter or excusing it entirely, and the killing was committed with one of the 4 states of mind: intent to kill, intent to inflict great bodily injury, reckless indifference to an unjustifiably high risk to human life, which is what we called depraved heart murder, or intent to commit a felony, which gives rise to the felony murder rule. Voluntary manslaughter is the heat of passion. So, voluntary manslaughter is a killing that would be murder, but for the existence of adequate provocation. Provocation is only adequate if it would arouse sudden and intense passion in the mind of an ordinary person, causing them to lose self-control. The classic examples being exposure to a threat of a deadly force, catching a spouse in the act of infidelity, or being the victim of a serious battery. And critically, there must not have been sufficient time between the provocation and the killing for a reasonable person's passions to cool off. Both conditions must be present. The third is involuntary manslaughter. Involuntary manslaughter is an unintentional killing committed either with criminal negligence or during the commission of an unlawful act. Criminal negligence means grossly negligent action or inaction when there is a duty to act. That puts another person at a significant risk of serious bodily harm or death. The unlawful act route can occur in one of two ways. Under the misdemeanor manslaughter rule, which is a killing committed in the commission of a misdemeanor, or a killing committed during a felony that is not statutorily treated as first or second degree murder. Section 4 is the statutory modification, the first and second degree murder. In jurisdictions that divide murder into degrees, a murder is a second degree murder by default unless it falls under one of the statutory aggravating circumstances that elevate it to first degree. The first aggravating circumstance is premeditation. The murder must have been deliberate and premeditated. If the defendant made the decision to kill in a cool and dispassionate manner and actually reflected on the idea of killing, even if only for a very brief period, even a few seconds, that is first degree murder. The second aggravating circumstance is felony murder. In many states, a killing committed during the commission of an enumerated felony constitutes first degree felony murder. The most commonly listed felonies in these statutes are burglary, arson, rape, robbery, and kidnapping. A really easy way to remember those is to remember the term BARC. Burglary, arson, rape, robbery, and kidnapping. Though other felonies that are inherently dangerous to human life are often included as well. The third aggravating circumstance is heinous murder, where some states make killings performed through torture or mutilation first degree murder. Now, this next one is very important for you law students, the felony murder rule. Here's the rule that shocks most people. If someone dies during your felony, you can be charged with murder, even if you never touched them. That is the felony murder rule. Any death caused in the commission of or in an attempt to commit a felony is murder, but this rule has important limitations. The defendant must have actually committed or attempted the underlying felony, because a defense that negates an element of the underlying offense will also serve as a defense to the felony murder charge. The felony must also be distinct from the killing himself. For example, a battery that causes a victim's death does not qualify as an underlying felony because the battery is not distinct from the killing. The death must have been a foreseeable result of the felony, and the death must have occurred before the defendant reached a place of temporary safety, meaning once the felon has made it to the place of temporary safety, any subsequent deaths are not felony murder. Section 5, the causation in homicide. So, to be liable for homicide, the defendant's conduct must be both the cause in fact and the proximate cause of the victim's death. Cause in fact means the death would not have occurred but for the defendant's conduct. Proximate cause means the death was a natural and probable consequence of the defendant's conduct. Superseding events can break the chain of proximate causation. Intervening events that are not foreseeable generally shield the defendant from liability. But here's what's important to remember. a third party's negligent medical care of the victim and the victim's refusal of medical treatment for religious reasons are both foreseeable risk, so the defendant remains liable in those situations. Traditionally, a defendant could only be held liable for homicide if the victim died within 1 year and 1 day of the injury. But most states that have reviewed this rule have abolished it. Now, Section 6 are the offenses against the person. So the first is battery. Battery is the unlawful application of force to the person of another that results in bodily harm or offensive conduct. The force can be applied through a third party acting under the defendant's direction or through an object that the defendant controls. And applying force to an object near, carried by, or attached to the victim is sufficient. Kicking a cane being used by a victim, for example, satisfies this element. The touching, however slight, must result in either bodily harm, such as a bruise, or an offensive touching, such as an unwanted kiss. Battery is generally a general intent crime, meaning intent to cause injury is not necessary. Only the intent to do the unlawful act is required. The next is assault. Assault is either an attempt to commit a battery or intentionally placing another in apprehension of imminent bodily harm. Here's a rule you need to lock in. If there has already been physical contact with the victim, the only crime that exists is battery, not assault. Once contact has been made, assault is off the table. The next is false imprisonment. So false imprisonment is the unlawful confinement of a person without valid consent. Confinement can occur by actual force, threat of force, or a show of force, and it works in two directions. It can mean making a person go somewhere they don't want to go, or it can mean preventing a person from going where they want to go when no alternative routes are available to them. The Model Penal Code requires that the confinement interference substantially with the victim's liberty. So false imprisonment is a general intent crime. The next is kidnapping. So modern statutes define kidnapping as the unlawful confinement of a person that involves either some movement of the victim or hiding the victim in a concealed location. Kidnapping is a general intent crime. Section 7 are the sex offenses. So rape. Common law rape requires unlawful sexual intercourse with a female against her will by a force or threat of force. However, the most modern rape statutes have significantly relaxed these common law elements. Rape laws are now often gender neutral. Rape can occur without force or threat of force, such as through involuntary intoxication, and the offense can involve sexual activity beyond intercourse. Rape is a general intent crime. Now, statutory rape. Statutory rape is a strict liability crime. That means even if the defendant had a complete, reasonable, honest belief that the victim was of legal age, it does not matter that that mistake is not a defense. Statutory rape requires only that there was sexual intercourse with a person under age of consent. The defendant's reasonable mistake of fact as to the victim's age will not shield them from the liability, because statutory rape is a strict liability crime, and the strict liability does not bend for good faith mistakes. Section 8 covers property offenses. So the first one we have is larceny. Larceny consists of taking and carrying away of the personal property of another by trespass with the intention to permanently deprive. Several elements here deserve attention. The carrying away element and requirement is satisfied by even a slight movement. We're talking inches, not miles. The property must be taken from the custody or possession of another person, meaning if the defendant had lawful possession of the property at the time of the taking, the crime may be embezzlement rather than larceny, and the intent to permanently deprive the owner of their property must exist at the time of the taking. You cannot form the intent afterwards. The next is embezzlement. Embezzlement is the fraudulent conversion of the personal property of another by a person who is in lawful possession of that property. If the defendant intended to restore the exact property taken, that is not embezzlement. The critical distinction here is possession versus custody. The defendant must have been in a lawful possession of the property, not merely in custody. Possession involves a greater scope of authority to deal with property than custody does. Low-level employees, for example, typically only have custody of their employer's property, meaning if they take it, that is larceny rather than embezzlement. The next is false pretenses and larceny by trick. False pretenses and larceny by trick look almost identical, but there is one critical difference that determines which crime was committed, and it all comes down to one word: title. False pretenses consisting of obtaining title to the personal property of another by an intentional false representation of a material past or present fact, not opinion, with the intent to defraud. The victim must rely upon the false representation, and that reliance must cause the victim to actually pass title to the defendant. The defendant must either have known that the statement to be false or have intended that the victim rely on the misrepresentation. Larceny by trick, on the other hand, occurs when the defendant only obtains possession or custody of the victim's property by misrepresentation, not title. That is the dividing line. If title passes, it is false pretenses. If only possession or custody passes, it is larceny by trick. The next is robbery. Robbery consists of taking and carrying away of the personal property of another from the other person or their presence by force or threat of force, with the intent to permanently deprive. The property must be on the victim's person or within their reach and control, meaning it must be in the presence of the victim, and threats must be directed at the victim, a member of the victim's family, or a person in the victim's presence. The next is receipt of stolen property. Receipt of stolen property consists of receiving possession and control of stolen personal property, knowing it was obtained in an unlawful manner by another person, with the intent to permanently deprive the owner. Crucially, the property must actually be stolen at the time the defendant receives it. If it has already been recovered by law enforcement and it is being used in a sting operation, for example, it is no longer stolen property. The next section is regarding offenses against the habitation. The first is burglary. So, common law burglary has 6 elements, and all 6 must be proven. Miss even one, and the prosecution cannot make the charge stick. Common law burglary consists of breaking and entering of the dwelling of another at nighttime with the intent to commit a felony inside the structure at the time of entry. Breaking exists if the defendant creates or expands an opening by at least minimal force, fraud, or intimidation. Entry exists if the defendant places any portion of their body or an instrument used to commit the crime into the structure. A dwelling is a structure that is used regularly for sleeping purposes, even if it is also being used for conducting a business, and ownership is irrelevant. Occupation by someone other than the defendant is all that is required. and the intent to commit a felony must be present at the time of entry. Forming the intent afterwards does not satisfy this element. The next is arson. Common law arson consists of the malicious burning of the dwelling of another. Malicious means either intentional or with reckless disregard of an obvious risk. The fire must cause actual damage to the structure. If someone lights a couch on fire inside the house, but no damage is done to the structure itself, that is not sufficient to satisfy the burning element. The next section is inchoate offenses. So the first is attempt. You can be convicted of a crime you never actually completed. That is an attempt liability, and it requires two things: specific intent to commit the crime, and an overt act beyond mere preparation. An attempt requires the specific intent to perpetrate a crime and an overt act beyond mere preparation that just falls short of completing the crime. Most states require that an overt act to be a substantial step forward toward the completion of the crime. Attempt merges with the underlying crime, meaning a defendant cannot be convicted of both attempt and the completed offense. Under the common law, abandonment is not a defense to attempt. Once the defendant has the intent and takes an overt act beyond mere preparation, they are guilty of attempt even if they later change their mind and walk away. Under the model penal code, however, a fully voluntary and complete abandonment is a valid defense, but the abandonment cannot be motivated by a desire to avoid detection or apprehension. The next is solicitation. Solicitation consists of requesting another person to commit a crime with the intent that the person solicited actually commit that crime. The crime of solicitation is complete upon the request itself. The other person does not need to agree to anything for the solicitor to be guilty. In most jurisdictions, solicitation merges with the substantive offense, and withdrawal or renunciation of the solicitation is not a defense. The model penal code recognizes renunciation as a defense only if the defendant actually prevents the commission of the crime. The next is conspiracy. And conspiracy is one of the most powerful tools prosecutors have, and here's why. It does not merge with the completed crime, and you can be convicted of conspiracy and the underlying offense at the same time. Under the common law, a conspiracy consists of an agreement between two or more persons to accomplish a criminal objective, along with the intent to enter into an agreement and the intent to actually commit the criminal objective. The intent to enter the agreement may be inferred from the conduct of the parties. A majority of states also require an overt act committed in furtherance of the criminal objective, and that overt act does not need to be criminal in nature. A conspirator purchasing tools to use in the burglary is a sufficient overt act, even though buying tools is entirely legal. A conspiracy terminates upon the completion of the criminal objective, and all acts or statements made after the termination are inadmissible against a conspirator. Under Pinkerton liability, a conspirator may be held liable for crimes committed by co-conspirators if those crimes were committed in furtherance of the criminal objective and were foreseeable. Withdrawal may be a defense to future crimes committed in furtherance of the conspiracy, but it is not a defense to the conspiracy charge itself unless the conspirator performs an affirmative act notifying all members of the withdrawal, gives that notice in time for the members to abandon their plans, and attempts to neutralize any assistance they previously provided. And unlike attempt and solicitation, conspiracy does not merge with the completed crime. A defendant can be convicted of both. The The next section is criminal responsibility, accomplice liability. So under modern statutes, there are generally 3 potential parties to a crime. The principal is the person who actually commits the illegal act or causes an innocent agent to do so. The accomplice is the person who aids or encourages the principal in committing the illegal conduct. And the accessory after the fact is a person who aids another to escape, knowing that the person has committed a felony. An accessory after the fact is only liable for the lesser offense of being an accessory after the fact. No full accomplice liability attaches. An accomplice is liable for all the crimes the principal committed and all other crimes that were probable or foreseeable result, provided the accomplice aided, abetted, or facilitated the commission of the crime with the intent that the crime be committed. Withdrawal is a valid defense to accomplice liability if the accomplice withdraws before the crime becomes unstoppable. If the accomplice only provided encouragement, repudiation alone is sufficient as a withdrawal. If the involvement went beyond mere encouragement, the accomplice must attempt to actually neutralize their assistance for the withdrawal to be efficient. The next section is the fitness to stand trial and insanity. So the fitness to stand trial. Before any criminal defendant can even be put on trial, they must first be found competent to stand trial. Under the Dusky test, 2 things must be true, and if either is missing, the trial cannot proceed. Under the Dusky test, the defendant must have sufficient present ability to consult with their lawyer with reasonable degree of rational understanding, and they must have a rationale as well as factual understanding of the proceedings against them. Both prongs must be satisfied. Now, the Insanity's 4 test. A defendant may be entitled to acquittal if at the time of the crime they were legally insane. There are 4 formulations of the insanity test. Under the McNaughton rule, a defendant is entitled to acquittal because of a mental illness. They did not know the nature and quality of the unlawful act or did not know the wrongfulness of the unlawful act. Under the irresistible impulse test, acquittal is warranted if, because of a mental illness, a defendant lacked the capacity for self-control and free choice, or the capacity to conform their conduct to the requirement of the law. Under the Model Penal Code test, a defendant is entitled to acquittal if, because of their mental illness, they did not have a substantial capacity to appreciate the wrongfulness of the act or to conform their conduct to the requirements of law. And under the Durham test, acquittal is warranted if the unlawful act would have been committed but for the act would have not been committed but for the defendant's mental illness. The next section is intoxication. So, voluntary intoxication as a defense, it only works for specific intent crimes. Try to use it for a general intent crime and you get absolutely nowhere. Voluntary intoxication, meaning the intentional ingestion of an intoxicating substance without duress, knowing that the substance is intoxicating, is a valid defense to specific intent crimes if the intoxication prevented the formation of the required intent. Voluntary intoxication does not apply to general intent, malice, or strict liability crimes. So it can be raised for solicitation, attempt, conspiracy, first-degree murder, assault, larceny, robbery, burglary, forgery, false pretenses, and embezzlement, but not for battery, rape, manslaughter, kidnapping, false imprisonment, murder, or arson. Now, involuntary intoxication, meaning ingestion of an intoxicating substance under duress or without knowledge of its intoxicating effects, is a valid defense to all crimes if the intoxication serves to negate an element of the crime. The next section is self-defense. A person without fault may use non-deadly force in self-defense if they are confronted with an unlawful force and reasonably believe it is necessary to protect themselves from an imminent use or unlawful force. When it comes to deadly force, a person without fault may use it if they are confronted with unlawful force and reasonably believe that they are threatened with imminent death or great bodily harm. In a minority jurisdiction, there is a duty to retreat before using deadly force if it can be done safely. But there are 3 exceptions. The duty to retreat does not apply if the attack occurs in the victim's own home, if the attack occurs while the victim is making a lawful arrest, or if the assailant is in the process of robbing the victim. Imperfect self-defense applies when the defendant kills another based on an honest but unreasonable belief that deadly force was necessary. In that situation, imperfect self-defense can reduce a murder charge down to voluntary manslaughter. As for the defense of others, a defendant may defend another person with force if they reasonably believe that the person being assisted has the legal right to use force in their own defense. The next section is duress. A defense of duress is available to a defendant if they reasonably believe that another person would imminently inflict death or great bodily harm upon them or a family member if they did not commit the crime. Under the Model Penal Code, threats to property can be sufficient for a duress defense if the value of the property at stake outweighs the harm done to society by the commission of the crime. The next section, mistake of fact. Mistake of fact is a defense, but whether your mistake needs to be reasonable depends entirely on what type of crime you're charged with. Get this wrong on the bar exam and it will cost you. So, a mistake of a fact is a defense that shows the defendant lacked the state of mind required for the crime. For specific intent crimes, the mistake does not need to have been reasonable. Any mistake will do. For malice and general intent crimes, the mistake must have been reasonable. And for strict liability crimes, mistake of fact is completely irrelevant. It provides no defense whatsoever, regardless of how reasonable the mistake was. Now, and that is all for criminal law, broken down all the way through from essential elements of a crime to homicide, property offenses, inchoate offenses, and every major defense. If you're studying for the bar or preparing for finals, go back through this video, take your notes, and make sure you can apply every one of these rules cold to any fact pattern they put in front of you. This is Big Law University. Know the law, own the room, and I'll see you in the next one.